Welcome to our YouTube video series on employment law. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we're going to be discussing the various common law tests utilized by the courts to distinguish between an employee and an independent contractor. Now, simply calling an individual an independent contractor, having an independent contractor agreement, and or paying an individual as an independent contractor does not necessarily make one an independent contractor. There are many circumstances under which that individual might in fact be engaged as an employee, and hence the importance of having a test or a series of tests upon which one can look at to determine whether that individual is in fact engaged as an independent contractor or they are engaged as an employee. So one of the preeminent Canadian cases in this is the Supreme Court of Canada's case in 671122 Ontario Limited versus Sagaz Industries Canada Inc. And in that case, Justice Major articulates the fact that there are numerous common law tests for determining whether an individual is engaged as an employee or as an independent contractor. And even though no specific test by itself is determinative, each of the tests are capable of providing direction and input based on the specific facts underlying the situation. And this is a critical component in that the facts determine what the relationship is, more so than any specific undertaking. So let us work through some of these common law tests to ascertain what factors are being looked at with each of the tests. Now, the first test is a control test. And the control test pertains to what level of control exists as between the parties, such that whether the individual has sufficient control so as to be determined an independent contractor, or on the converse side, lacking in that control and thus being an employee. So the aspects that we are looking at with respect of this, number one, the right to control the method of doing the work. Number two, the power to hire and control the method of hiring. Number three, the right to suspend or dismiss the alleged employee. Noting that an employer has a greater degree of control over their employees than they would over an independent contractor. The employer's rights over the independent contractor are limited to terminating the contract for services where the work is not performed satisfactorily, whereas the employer has a right to suspend, dismiss, or otherwise discipline the employee. Number four, the payment of wages or other remuneration, noting that the manner of payment may indicate whether a sufficient degree of control is present in order for there to be an employment relationship. If a person is paid proportionate to the amount of work done, rather than the time occupied or for a lump sum, this may indicate that such a person is being employed as an independent contractor. Number five, the right of the employer to demand exclusive service from its worker. Number six, the right of the employer to determine the place of work. Number seven, freedom of action in performing the task, including the degree of supervision and the ability to designate. Number eight, retention of the right to prescribe the exact work to be done. And number nine, the degree of accountability on the part of the person performing the work. Now, moving beyond that, there is another common law test, and this is known as the fourfold test. And this test still retains as a central concept the control element, but it also examines some additional factors to provide a means to distinguish between an employee and an independent contractor. So, the first point is the control aspect. And this may be defined as the power to control the method of doing the work. In other words, does the employer have the right to tell the employee not only what to do, but how to do it? Direct or immediate supervision is not essential. It is the power of control, rather than the day-to-day exercise of supervisory control, that is significant. Number 2, the ownership of tools. And here, tools does not refer only to such items as hammers, laths, and cleaning mops, but can also include any item used at the workplace, such as forms, manuals, promotional literature, and a telephone. A person who owns all the equipment necessary for the work they do is more likely to be an independent contractor than an employee. Likewise, if the tools are supplied by the purported employer, it is more likely indicative of an employee-employer relationship. And number 3 and 4, sort of related. Number 3, chance of profit, and number 4, risk of loss. Now, these two elements are usually linked together, where typically an independent contractor is in business for himself or herself. And this suggests that there is a financial investment in their undertaking, so there are variables other than their own labor subject to their influence and provide a chance of risk of profit and a risk of loss, which is something that is not so preeminent with an employee. The employee knows what they're getting paid, set amount of pay, typically on an hourly or piecemeal basis, such that they perform the work, they get paid, they don't really get much more in the way of additional money. If they perform the job at a faster pace, they get paid based on the work they get done. Next common law test is known as the organizational test. The organizational or integration test is attempting to examine the employee or that individual's integration in the employer's organization, in which case the individual is an employee or a mere accessory to it, in which case they are an independent contractor. Now, one feature of this seems to run through the instances is that under a contract of service, a person is employed as part of the business and their work is done as an integral part of the business. Whereas under a contract for services, a person's work, although done for the business, is not integrated into it, but is only accessory to it. So this is a pretty difficult test in some respects to apply, and Justice Major from the Supreme Court of Canada noted this. Because if the question is whether the activity or work is integral to the employer's business, the question can usually be answered in the affirmative. If the test is applied to demonstrate that without the work of the alleged employees or the employer would be out of business, a factual relationship of mutual dependency would always meet the test. Nonetheless, Justice Major acknowledged that the organization test can be useful if properly applied, looking at the question of integration from the perspective of the employee and not that of the employer. If the test is applied from the employer's perspective, it is easy to assume that every contributing cause is arranged purely for the convenience of the larger enterprise. And finally, we have the statutory purpose test and economic dependence. Now, statutory purpose test requires us to put some reliance upon the statute. And what we're looking at typically is employment standards legislation based on the governing province and how that relates into the process, and whether the employment relationship should be assessed by reference to the purposes of the statute, which is often characterized by intending to provide certain benefits to a person who, by reason of their economic dependence or lack of bargaining power in the marketplace, might otherwise have worked on terms below the basic minima established by the employment standards legislation. Because whereas such legislation is not designed to protect or underwrite the independent businessman, it is designed to protect those who are dependent on a company or another individual for their employment. So this is the basis upon which we look at the obligatory nature, the dependence, and the statutory interpretation to ascertain the value of that particular scenario. And as you can see, each of these common law tests build upon one another, have their own limitations, but also provide some scope depending on the particular relationship that exists between the party that's hiring and the party that's undertaking the work. And it is by looking at these multiple common law tests, drawing upon them, we are able to find factors that either push towards an individual being seen as an employee or being seen as an independent contractor. And that is the purpose of having multiple tests, using those multiple tests, and finding the correct assessment so the application can be done properly and as to what the law intends and what the purposes of the legislation are oftentimes. And that is the value of the various common law tests to ascertaining whether an individual is working as an independent contractor versus an employee. Thank you.